Okay, guys. Hey, welcome to this unexpected live this morning. And with me, of course, is lawyer Travis Williamson that's joining us today. And we're going to go over a couple of documents that had come out this morning. So I messaged Travis and he said, hey, can you do a live with me? And what did you say, Travis? No? No, just kidding.
I said, absolutely, I would. It's fortuitous. My schedule this morning allowed it. And
Yeah,
you know,
thank you.
just so happy that you had super quick um, access to this real time, pretty
Yeah,
much. And
yeah,
that's really, really cool that you have this access. And um, so,
yeah.
yeah,
You're right
let's
on it.
go through it. Yeah.
Yeah. Okay. So, okay, so this is, of course, is relators. Am I saying that right? Relators, right? Motion for leave to respond.
Relator. Yeah.
Relator,
Relator. Yeah.
relators. Okay, relators.
So,
Motion for. Go
yeah,
ahead.
scroll all the way to the top of that,
Yep.
all the way to the top. Okay. So, first thing I want people to notice is it says filed. Just keep that in mind, filed, and then the date and the time. Uh, that is 9 a.m. Eastern, I'm guessing. Um,
I'm gonna think so.
so it was filed 2 hours. So it's like fresh out of the oven. Okay. So, and it's in the Indiana Supreme Court. And it relates to the first petition for writ of mandamus or in the alternative prohibition, which involved my favorite lawyer, PFD. I'm only going to say it one time, who is the princess of fucking darkness when it comes to the ACR. And we're going to get into what that is. So don't worry if you haven't been keeping up on this. We're going to get you all up to date. So this is relating to the first petition, which relates to how documents should be filed in a case, whether they're confidential, sensitive, et cetera, et cetera. So the name of this pleading is Relator's Motion for Leave to Respond to Respondents' Objections. So again, if you've been following things, the attorney for the court, which includes Judge Gull, I'm going to try and refer to it rather than Judge Gull. I'm going to be as much as I can calling it the court, just to take the personalities out of it. And, you know, that's what good lawyers do. And we're going to see that that's what Maggie and the legal team do in these pleadings. But so it's leave to respond. So just real quickly, in the rules relating to criminal procedure and the appellate rules, it sets out the order and the timing on briefs. And normally there's a motion or a petition, and then it provides that the other side has so many days to file a response or opposition. And then typically it allows for a reply, the person who filed the petition, to get the last word and file a legal document. However, in some situations, like with this petition, for example, in the appellate rules, it provides for a petition and a brief in support of that petition. It provides for a response, and you label it how the respondent labels it, objections, leave to respond to respondent's objections. And then if it doesn't specifically provide for a reply, you need to seek leave of the court. And we saw that with the amicus briefs. they file a petition, or they file a motion for leave to file an amicus brief, and then that brief is only officially part of the case if the court grants the motion to file it. The rules typically provide that you need to provide a copy of what you intend to file. So we'll see that in a second. Okay, so if you would do me the honor of reading what this motion asking the court for permission to file a reply brief, starting at the paragraph 1 there. It's not long. We'll just go through this quickly, and then we'll get to the meat and potatoes after we go through this. So would you please read for us in that beautiful, entertaining voice and tone you have the brief?
Okay. Now, just to ask you quickly before I start, do you want me to refer to all those numbers and that in there?
No, just start paragraph 1 and start
Okay.
with the original.
Okay, so the original action rules do not provide for responses to respondents' objections, but this court has granted leave to allow the same. See state EX. Is that rel? How do I say that word there? Rel.
Okay,
Rel.
so it's state ex rel. So so when you see that, that means the ex rel means there's a relator, and when there's a relator, that means it's a direct action filed, and it's typically a petition for a writ of some kind. And so she's citing cases that say exactly what I said. The original action rules, which a petition for a writ is an original action. And what they mean by original action is you don't file those in the district trial court level. You don't file those in the Court of Appeals of Indiana. You file it in the highest court, the Supreme Court of Indiana, because they don't want, these petitions for mandamus, everyone will recall, this is when a public official like a judge is required to do something by law, absolutely required to do something by law, but refuses to do so, or is required by law not to do something, specifically can't do it, but does it, and you want to prohibit them. You don't want different appellate courts, intermediate appellate courts, deciding those types of things. You want one court coming down with a rule that applies to everybody below it. So that's the reason why it's an original action. So we don't need to read those case names or whatnot.
I was going to say, because this word right here, I was going, yeah. Okay.
So what she's saying is what I just said, that it doesn't provide specifically for a reply or a response. Therefore, you need to seek leave, permission of the court to file the brief. So she's laying out the law and citing Indiana law in support of that. Okay, paragraph 2.
Okay, so a response is needed here because respondent has represented to this court that it's November 13, 2023 order purporting to correct the errors raised in their original action, resolves most of the public access issues raised in the petition, and moots their original action. Brief in opposition, page 14. And did you want to stop there? Do you want me to read the next one still? Or
let's go to the next one. I think that's pretty self-explanatory. The relator is asserting that they haven't been, there's more than meets the eye, and we need to let the court know that there are continuing issues.
issues. Yeah. Okay. So this response is necessary to show that the representation is incorrect and that
Ooh. Okay, keep going.
the November 13th order at most corrected 20% of the errors Relator has identified.
Ooh, okay. We got math and you know,
Right. 20%.
the choice of word incorrect. We'll see in the brief what they're claiming. We'll just have to wait till we get to that. But there's a claim here that what was filed on behalf of the court was incorrect, and we'll see if that's being diplomatic or not. And then 20%. So that's 2 out of 10, 4 out of 20. Now I went through in a thing for you when they filed the order, when the court filed the order ordering things to be filed in the CCS or CSS, whatever it is, when ordered that 2 documents be unsealed. I kind of went through the brief quickly, the original petition that was filed, and I saw one thing that was glaring was the stated file a motion that everything be sealed automatically. And then I saw that some things were taken care of, but other things did not appear to be taken care of. And I said, we'll need to see in the response if they think everything has been taken care of to their satisfaction or not. And we're now at that stage, and things have not been taken care of to their satisfaction. So only 20%, and so they have not mooted the original petition for writ of mandamus according to the relator, and we'll see what they think is still hanging out there. Read the next one for us, please.
Okay, so this response is also necessary because respondents' objections demonstrate a continued misunderstanding and misapplication of the responsibilities and requirements of the ACR rules.
Next, please.
Yeah. Relator therefore files this response asking that a writ of mandamus and prohibition be issued to require that all the errors be corrected and to ensure that the same errors do not continue to be made in this case as it progresses forward. Respectfully, Maggie L. Smith.
Okay, so she's giving a compelling reason. She's indicating Ms. Smith and Ms. Weinecke. I just saw her as Kara. I apologize, Kara, in advance for butchering Weinecke or Weinecke or and Jesse Cook. And all right, let's pull up the other one that I've marked up.
Okay. That's too big. Too small. Sorry, it's just you just touch this thing and it moves. Is that good? Is that good, you guys? Thanks. There we go. That's good.
Not over there. I'm pulling it up on mine so I can read it. That's it. Okay. So you ready to get into this one? This is the juicy one. Okay. Looking forward to y'all have Thanksgiving in Canada?
Yeah, ours is in October though. I say that we're smart because we have it so that you can have a break between Christmas, but you guys have yours over there in 2 days, and then you guys roll into Christmas. A lot of money getting put out at one time.
And
But yeah,
then what's the traditional main thing? Is it turkey or?
yeah, same idea. It's basic. It's the same as the U.S. What the U.S. does, really. Same
Y'all
thing.
get,
Same idea.
well, you have Canadian turkeys, or do you get a Virginia
Yeah,
turkey?
yeah. No, we bring them all up from the States and eat them. Yeah, for sure. No, just kidding. We
And
probably
then,
put. Yeah.
the
Go ahead.
highest elected official in Canada is the Prime Minister,
Prime Minister. Yes,
and
he's.
that's currently a Trudeau.
Oh yeah, and he's a pretty good looking prime minister, to be honest. When he keeps his mouth shut, it's even better. But honestly, I mean, his dad used to be the prime minister back in the day.
Oh yeah, yeah, yeah.
Yeah, right. And you know what? So there was always this gas station called Petro gas station. And my when I was a kid, my mom always said it stood for Pierre Elliott Trudeau rips off Canada.
Yeah. Um,
But
there
yeah,
were
anyway.
several presidents that U.S. presidents that really liked his dad a great deal. Anyway, oh boy, Charmaine's giving me kudos and interrupts my train of thought because I'm scared of her. Okay, so all right, everyone should have had time to go get another cuppa. So let's get into this. So this document at the very top, instead of saying filed, it says received. So anytime a party submits a document to the clerk that hasn't been approved for filing, it's marked received until a judge, it's been Judge Rush, the Chief Justice of the Indiana Supreme Court, until she either approves, grants the motion for leave to file, or denies it. If she grants it, it will be filed. So this same document, if it's granted in a few days, will be marked filed. So when people see that, don't freak out. All it means is that the motion that we just went through for leave was granted, and this is getting filed because you're required to submit this with your motion for leave to file a response. Okay, skipping down below, pending acceptance by the Indiana Supreme Court. Then in the past, I've referred to Attorney Smith, Ms. Smith, as the PFD. I already said what that stands for at the top, so I won't.
Can I say it? Prince of fucking darkness.
It's your show. You can say whatever the fuck you want.
I was gonna say, can you just explain to everyone why you've called her that? Because I remember when we first heard it, we were rolling on the floor, laughing our asses off so bad because it was all of a sudden here's Travis talking, then all of a sudden that comes out of his mouth, and we all died laughing. But can you just explain again by chance to them?
Well, in prep for that show, that live, I briefly looked up the three lawyers, and Ms. Smith is from a very prestigious firm that handles a lot of major civil litigation, but she has a specialty, a subspecialty in this access to court records set of rules, the ACR. And I followed up on that a little bit, and she is like the guru of the ACR, and the petition quoted extensively about that these rules lay out a very clear plan and set of expectations for judges, litigants, and the media to follow. And it's an incredible set of rules that not every state has. It's more ad hoc, meaning, you know, case by case. Oh, well, this was a problem here. How do we take care of it? The federal system's got a way that they deal with it, but really they're on the forefront of having these rules in place to be a comprehensive guide. And so when I saw that, you know, that's kind of a moniker I've used over the years. It's from a movie. I'm big on movie quotes, as you know, but an attorney that is a go-to attorney for that particular area of law and knows what they're doing and knows how to handle themselves in court, whether it's trial or appellate level, I've always referred to as either the prince or princess of fucking darkness. And to minimize, especially since we're, you know, in the morning hours in North America, I wanted to kind of keep the F-bombs.
You were going to save them for dinner, except for you gave them to us for breakfast over here. Yeah, we're good.
But it's a term of respect, most definitely.
I'd like to be called.
And then Kara is the same, but with post-conviction relief in Indiana. And I believe Ms. Cook is a law professor at the University of Indiana Law School. Gosh, I hope I got that right. I'm going from 10 days memory. I'm normally super bad with names, but all three were quite impressive. But somebody had mentioned that they thought that Ms. Smith had done the bulk of the work on the brief, you know, fantastic job on the brief, because it's very difficult. Again, very, very difficult to get a court to grant the filing of a petition for writ. Most of them, they get filed and the judge that reviews it summarily dismisses it. But they got the court to accept it and order the respondents to file a brief if they wanted to do so, which they did. And so here we are. So let's get down to see what PFD thinks of the response filed by the
okay. Do you want me to scroll on past this?
Yeah. Nobody reads the table of contents.
Yeah. Well, you know, I like to think I do, but I actually don't either.
It's very helpful, you know, when you're responding or whatnot. So just read that. Go ahead and read that first paragraph, not just the highlights. Just start from there. So this is her summary of what she's going to be telling us. So let's read that first paragraph.
Okay, so Relator appreciates that respondents has corrected a few of the errors that had left the media and public largely in the dark about this case. Relator, however, is concerned with both the tone of and the approach suggested by respondents. Objection, both of which indicate a continued misunderstanding and misapplication of the mandates found in the access to the court's ACR rules.
Stop there. Okay. So, you know, people can interpret for themselves, and you have to have kind of what the response of the court was. But as I was reading through it, I felt, you know, there was the initial stuff about it's not appropriate for writ of mandamus and so on and so forth. Then after it went through, the technical challenges, when it got, assuming this court finds that it is appropriate and starts talking about the merits, what we call the merits, I thought it was, to me, condescending. And I don't know, I'm not trying to put words in the brief here, and I don't know if that's what they thought, but they had concerns with the tone as well, that there's continued misunderstanding. And then I don't know if you remember last night, I said one of the reasons they may have not wanted this transcript out, and she fought so hard not to let it out, was that, and I said, we're probably going to see references to this transcript about that the court does not have a very good understanding of the ACR, and things that the court said in that in-chambers meeting, hearing, whatever the hell it was. Even my limited understanding of the ACR, it just didn't sound right to me. And I said, we're probably going to see quotations or references to this transcript, and we'll see if I was right or not. Go ahead and read the next few paragraphs, please.
So contrary to the respondent's claims, the trial court has no discretion to ignore the absolute duties contained in the ACR rules. Instead, not only are those mandates unequivocal, but those rules make the trial court directly responsible for compliance when, as here, it becomes aware that the ACR mandates are not being followed. Do you want me to keep going for one more? Okay.
Yeah. Well, so that last one was, that's referring to the throwing the clerk under the bus. Keep going.
Sure. In this regard, a trial court may not abdicate these absolute duties to another entity and then blame that other entity when the ACR rules are not being followed. This is particularly true when the trial court itself issues an order expressly instructing that the other entity, here, that the trial court clerk, to violate the ACR rules, and that entity simply complies with the trial court's orders.
Wow, that's pretty strong right there. Okay, keep going.
Okay. Moreover, we have now learned that respondent in the first instance chose the sua sponte, inserted itself into, is that policing? Do we say policing? I would say policing, right?
Yeah.
Itself into policing. Okay. Whether I had policing in my head, but I'm like, that's not right. Into policing whether to allow filings the parties designated as publicly accessible, and then decided improperly that the documents were to be excluded, and instructed her staff to change the designations and make them hidden. And then let me just finish off that.
Okay. So moreover, we have now learned that respondent in the first instance chose to sua sponte, insert itself into policing whether to allow the filings the parties designated as publicly accessible, and then decided improperly. So this was that discussion in the transcript we were going over last night, where she was saying, no, you filed it, and then but I had to yank it because it had the warrant in it. And and that I'm going, that's where I'm thinking, well, we're probably going to see quotations to this. So I have my note, first learned, the suspense is killing me, because I'm thinking, I bet I'm right, and we're going to be hearing about the transcript, because what else would it be that they learned recently from? You can read that next paragraph.
Sure. Respondent has since issued an order purporting to correct the errors identified in Relator's petition. The chart below, however, shows that the trial court corrected a mere 20% of those errors.
Okay, so now we go down to this really cool chart. And this is something I try to do when I can, is have my staff prepare a chart, whether it's for a pleading, but especially in trial for closing argument, a list of things that we contend constitute reasonable doubt or whatever it might be. People learn differently. Some people retain more if it's presented to them verbally. Some retain more if it's visually, but almost completely down the line, if you do both visual and oral, the amount that they retain is substantially higher than if you do it just one or the other. I'm the type of person that like podcasts, if I just am listening, I sometimes have to go back 2-3 times, or an audiobook. But, I'm, like I've said before on here, I'm old school, I'm analog. I need to be able to flip back and forth between pages. And if it's laid out for me, I'm just able to retain it a lot better and understand it a lot better.
Yeah,
and I just think this was an excellent job. So we've got several things that she says are remaining. And can you just read the left-hand column, those items, the excluded court records, reinstate? Can you read those?
Okay, you just want me to go right down?
Yeah, on the left-hand side.
Yeah. So the excluded court records referenced in the June 28, 2023 order must be made publicly accessible. Reinstate the September 18, 2023 Frank's memorandum as a publicly accessible filing. Make the state September 25th, 2023 filing publicly accessible. Make the October 12th, 2023 filing publicly accessible, as well as the October 19th one. Reinstate the 4 different October 25th, 2003 or 2025 and 2000. What am I saying? 2000 October 26th one. So those were the ones, right, that she had stricken, right? Filings as publicly accessible. Every court record excluded from the public access must be accompanied by an ACR form. A public access version and non-public access version of any court record excluded from public access must be filed.
So those are the ones that they're contending have not been complied with and still need to be resolved by the Indiana Supreme Court. On the right-hand side of the column, for those that may be listening in and aren't watching, you're at work and trying to act like you're working. And so she's given a reason why doesn't believe the response by the court addressed. Some of these we know. Reinstate the Frank's memorandum as a publicly accessible document. We know that the order that she issued after the petition for writ of mandamus was filed, yes, she did do an order that took care of a couple of things, but she turned right around and said that the new attorneys needed to submit a redacted version. and I commented on it. Bob from Defense Diaries commented on it. I said, well, I put you on the spot, didn't I? I said, okay, let's take a hypothetical document and just pretend that you could be put in jail for a day or two or fined a significant amount of money if you didn't take out what you're supposed to take out. What would you like to have in order to redact it? And we talked about that. And you said, well, I'd like some clear rules or clear understanding of what goes in there, what doesn't go in there. And I think everybody would like that. And it's still not existent. So let's count those up, these no's. How many no's we got there?
Okay, so we got 1, 2, 3, 4, 5, 6. Oh my God, I lost track already. I lost track already. Hold on. 1, 2, 3, 4, 5, 6, 7, 8.
Okay.
8 news.
Okay. And then now let's read the two that she that petitioner Richard Allen concedes have been mooted, have been taken care of.
Okay, let me just try to make this bigger for the people. You just touch it and the thing goes big. Okay, so make this one right here to make the 118 documents on the zip drive publicly accessible on the CCS itself. Yes. Make the June 20th, 2023 and the July 5th, 2023 filings publicly accessible. Yes.
Okay, so we got 8 plus 2. Sorry about the typo, have an ampersand there, but that's good anyway, because I miscounted. There wasn't 7, there was 8. So we got 8 no, 2 yes. That's a total of 10. Easy math. So 80% unresolved, according to Richard Allen, 20% mooted. Go ahead and read the next paragraph there.
Okay, so it says, as this chart reveals, respondents claim that this original action has been mooted as a result of its November 13th order is wrong. Respondents' response instead demonstrates a continued misunderstanding and misapplication of the responsibilities and requirements of the ACR rules.
Yeah, and I just put a reminder. It's mooted, not muted. Mooted means you've complied with what the other side has asked for, therefore no actions needed by the court. We talked about that from the beginning, that order was an attempt to moot the petition, that we needed to see what Richard Allen's counsel and their response brief thought was taken care of. If they thought everything had been taken care of to their satisfaction, they would have submitted something that says, we concur, it's mooted, no action by the courts needed. That frequently happens in more basic, very simple things with the clerk's office. They refuse to accept a filing from a prisoner or something. It's pretty basic. Go ahead and read that last paragraph of the summary of the argument.
Okay, Relator therefore files this response. And hi, Adam. Asking that a writ of mandamus and prohibition is to be issued to require that all errors be corrected and to ensure that the same errors do not continue to be made in this case as it progresses forward. This original action provides this court with a unique and much needed opportunity to educate the bench, the bar, the media, and the public as to the mandates of the ACR rules.
So again, this is an example of the gift that Maggie and her colleagues have, PFD. They're keeping it to the case at hand, because advisory opinions, Indiana Supreme Court or any other state Supreme Court, they have rules against just issuing advisory opinions, seeing stuff out there and they say, well, let's do an opinion on this. There has to be a case. So she says, in this case, there are still continuing errors and misunderstandings. However, to get a court interested in an original action like a petition for writ of mandamus, they're not, even though something technically may be incorrect, they're just not really keen on fixing, tiny errors. And so you want something that does have broad appeal, does have something that would be of interest and help broadly. And so it's phrased as much needed opportunity to educate the bench, the bar, the media, and the public as to the mandates. And, the public includes content creators, channels that have been talking about these different pleadings, and those that don't have the assistance of somebody maybe with legal training or have a media person to explain the way things should go and how media gets access to things, how media contests something that's been designated confidential or something. In this case, I've seen a lot of misunderstandings that have grown out of this culture she's tried to establish, and we'll get to it, like putting in the names of the deceased, and oh my gosh, and we're gonna get into that this case is the exception. The other cases aren't run like this. I don't want to consume everybody's time just reading this stuff to be reading it. So I'm going to just kind of summarize what we've got here. So the first point is trial court has no discretion to violate the court's ACR rule mandates and cannot abdicate its duties to another. So this is about, you can't throw the clerk under the bus. You can't, even if you think it makes more sense than the ACR rules, that it expedites things, it gets it out quicker. Sorry, you can't ignore the law. Now, you might be able to do that in conjunction with following the law, but you just can't come up with stuff on your own, even if you're, an innovator. Sorry, the Supreme Court issues these rules, I think, not the legislature. So the Indiana court has issued them, and they expect courts and judges to follow them. If you think there's a better way, there's a process for amending the rules to make them better. But so they list what the requirements are. Indiana court records are to be open and accessible by the public. Rule 4A and B. Sorry about the dog. FedEx is here. There are only two ways a court record may be excluded in an otherwise public case. A, it falls within ACR 5B or C, or
Which one are we on?
this will be over in a second. Please hold. Please hold. Please
no
hold.
problem. No problem.
Please hold.
So, Adam, do you think that we could throw who just underneath of a bus?
I can't even hear you. I'm
Not.
surrounded by commotion.
It was funny just watching Adam talk when he was muted. That was
Right.
Yeah. But are you good?
Why are we trying to throw who dis under the bus?
Well, if we can't throw the clerk underneath the bus, we might as well throw who dis. She's in Indiana. Fair enough.
Okay, that's over. So falls under 5B or C, and then extraordinary circumstances exist, and all of the requirements of ACR 6 are met, and Rule 6. Third requirement, parties may never agree or use Trial Rule 26 to exclude a court record that otherwise does not satisfy Rule 5 or 6. That's right out of the Rule 5 commentary. Every record excluded from public access must be accompanied by an ACR form identifying the specific Rule 5 grounds upon which exclusion is based. And then last, unless every single piece of information in the document can be properly excluded, there must be a public access version and a non-public access version of the document. The public access version has the confidential information redacted, but also still ensures all of the non-confidential information is publicly available, and then cites the original brief in support of the petition they filed. Then this next part, getting the clerk. Would you read that? Finally, nothing in the ACR rules. Would you read that? And then that first number one, read up there.
So finally, nothing in the ACR rules allows the trial court to abdicate its judicial functions to another entity. Here, the clerk can then blame the other entity when the mandates of the ACR rules are not met. This is even more applicable here, given that the trial court itself issued the order instructing the clerk to violate the ACR and the trial rules and remove all of Allen's filings from both the CCS and the electronic case file.
So that's not good. Makes the opposition and objections that were filed by counsel for the court appear a little bit disingenuous. Oh, there's a footnote and Adam's here, so that's perfect timing because Adam likes footnotes. Just citing a couple of cases. Court has no power to abdicate its judicial functions. And then another case, we are dismayed by the trial court's disregard for the statute that governs a defendant's rights during sentencing, making clear this amounted to an improper abdication of the trial court's statutory obligations. So that would be an example because it didn't deal with the clerk. If you could go down to the next page and read the other two reasons why they feel the court tried to abdicate functions to the clerk. So we read the first one about the order instructing the clerk, and then we got 2 and 3. Would you read those, please?
Okay, so as discussed. Okay, go.
As discussed below, the trial court has now admitted that it has sua sponte inserted itself into the determination of whether the filings must be excluded and instructed its internal court staff to have the filings changed from public filings to excluded filings. The trial court turns its Allen County staff to set up an alternative website containing the 118 improperly excluded documents instead of ordering the clerks to make these 118 documents publicly available on the CCS.
There's Captain Howdy.
Go ahead.
Go ahead.
So we've talked about kind of this crossover, and people have asked, does the clerk have to do it? And I still don't know the answers, but I can tell you what the answer would be on behalf of the relator right here. In all of these instances, referring to 1, 2, and 3, the clerk simply complied with the trial court's orders and instructions as the clerk must. So they're calling out this, it's the clerk's fault. And going back to number 1, the court itself issued the order instructing the clerk to violate. So this is kind of the, don't do as I say, do as I do. We've all had, or kids, or nieces, nephews, friends' kids, try and use this, seen parents, the authority figure, use this argument. Well, you do it. Don't do as I say, do as I do. That they're just pointing that out, that it's kind of disingenuous to say this is all the clerk. And, once I realized it and recently reviewing the court docket, I, ordered all of this stuff fixed. It's calling that out. The next point they want to make is that, Aspen, would you read 1B, the heading trial courts have?
Absolutely. It says trial courts have the absolute duty to ensure compliance with the ACR rules with regard to the court's own actions, and once the court is made aware the rules have been violated. Respondent, you want me to keep going?
No, let's just see if we can. A respondent repeatedly claims has no duty to enforce the mandates of ACR rules. Not accurate. But although it had no duty to do so, respondent has now revealed that, in fact, it has affirmatively inserted itself into policing whether documents must be excluded in the first instance. And then I've got a note to myself, transcript and read letters. Again, last night when we were talking about the transcript here in this channel, we talked about, I said, I'm pretty sure we're going to see references to this transcript in a response by Richard Allen's attorneys. And here's the first instance. So PFD and her team, the transcript was publicly filed yesterday morning. Is that right? Adam or Sunny, the transcript we went through.
I answered, but I forgot I was muted. So yes, the answer is yes.
Okay. Now they may have a more advanced access, but even so, even if they got it the day before yesterday in the afternoon, obviously they've been working pretty hard to have this thing filed bright and early for us to have some coffee over. So it points out in the transcript of the October 9th hearing, the trial court admitted that it had flagged the Franks filings discussed below, and sua sponte inserted itself into the determination of whether the filings must be excluded. Ultimately, the court instructed its internal court staff to have the filings changed from public to excluded filings, and as discussed below, did this incorrectly. I don't think they're saying it's improper for the court to do it sua sponte. Why they're pointing it out is that it's disingenuous to say this is the clerk's fault. You're the one that did this. And then on top of that, their position is if you're going to do it, you got to do it right and do it per the rules. They're reasserting the arguments that they made. They didn't know in the original petition. They said, quote, someone, unquote. Obviously, they were making an educated guess that the someone was the court, but you don't want to lay blame on someone until you know, and that's why they wanted the transcript. I'm sure they asked Mr. Rosie and Mr. Baldwin, well, what did she say about that? And I could just see, man, there was so much going on. I wrote down the items that she said were gross negligence, but I can't be 100% sure. But she did say she did something with the thing. Well, a good lawyer, before you make a specific accusation against a judge, you want to know, and so they just referred to it as someone caused these documents to be removed. Someone pulled a particular motion, and they're pointing out that they now have that information. And let's go down, Adam. I'm on page 9. And if you go down below that quotation, it says, this absolute duty is even more applicable in this case. Are you with me?
Yeah.
Would you read that and the 3 subparagraphs, please?
Sure. It says this absolute duty is more applicable in this case, given that the trial court itself issued the very orders mandating improper exclusion by instructing the court to violate the ACR and trial rules by ordering the clerk to remove all of Allen's filings from both the CCS and electronic case file. Having Allen County Court Executive set up an alternative website containing the 118 improperly excluded documents to ease the burden of the clerk of Carroll County, instead of ordering the clerk to make these 118 documents publicly available on the CCS. Shout out to John McAuley for doing that. Inserting itself into the determination of whether the filings must be excluded and instructing its an internal court staff to have the filings changed from public filings to excluded filings.
Okay. Who's John McGowan?
He's the one. He was the Allen County court employee that was charged with putting together the website for the 118 documents to be.
Yeah. And so, as we mentioned earlier, probably perfectly fine to do a supplemental access, but you can't decide on your own to replace one with the other. And, I think the court acknowledged that in its order, ordering that the 118 documents get uploaded. And so I'm going back up to that first transcript. Designation, bottom of page 8. I just wanted to see how they reference the transcript. And they reference it by supplemental record of proceedings in 23 SOR 311, page 5. Okay, so that's page 5 of the transcript they refer to. And so now we're at the top of 10, top of page 10. Sorry, we're going through this together in real time. Let's go ahead and read that paragraph at the top of page 10 in short. Somebody, please.
Can I take this one, Adam?
Yeah, the cleaning people are vacuuming, so that's good.
Since I'm short, I'm going to read this one. In short, although respondent now takes a position before this court that it has been a hands-off observer and it is the clerk's fault that all these documents have been excluded, this is not accurate. This trial court has an absolute duty to correct the ACR rules violations when it becomes aware of them. And if this trial court is going to direct the clerk on such matters, then the trial court must comply with the mandates of the ACR rules when doing so.
Okay. So can we see if there's any questions up to this point?
Absolutely.
Or comments?
Sure. Cake chat, it's up to you. You guys got any questions or anything?
I have a question.
I feel like you have one.
When I was reading this when it came out earlier, and I haven't read it fully, I haven't read it really in depth, but I feel like the strongest argument that that the writ has, in my opinion, is the part where they mention the not following the ACR. Do you agree? Or
yeah, because no, you're absolutely right, and it's why they found a lawyer like PFD who's an expert on the rules and has cited pretty much every a legal assertion you see references a rule or a commentary to the rule, I suspect from what I've seen so far, there's a dearth, look it up, of case law on resolving these issues under the ACR. And that's why this part of it is extremely important. And that she said, this is, it looks like we're going to have a continuing problem in this case, but we need to educate the bench, the bar, the media, and the public about the ACR. And this is a perfect opportunity to do it. And to your point, Adam, writs of mandamus are only appropriate if a public official, like a judge or a clerk, has a clear duty to do something and doesn't. So anything that's discretionary, like ruling on a Frank's motion or ruling on an objection at trial, those are discretionary. Judges hear both sides and they call balls and strikes. But on something that a public official is required to do, that's the only thing that's suitable for a petition for writ of mandamus. And so, yeah, absolutely. She has to show, Maggie and her colleagues have to show the court that there is a absolute requirement under the ACR to do something. So that it's a very astute observation, as per usual, on your part regarding that.
Thank you.
Travis, just to ask you, because in chat they got a little bit of a debate going on. So Art of Deduction says at Charmaine, well, it's not that obvious if both oral motions were approved, hence the 19th, October 19th, by record of in the chamber. Charmaine says, Art and True Crime, I really want to agree with you. I do, but there was only one oral motion. And then, so yeah, you want to maybe tackle that one about that in the transcripts yesterday with.
Well, yeah, I'd respond this way. So I'm glad that, as usual with your channel, I can't see the chat, so I'm relying on you. I'm looking at the pleading in a blown up view so my old tired eyes can read it. But it sounds like, yeah, exactly what you said, a respectful debate. So what they're talking about there, I think, is going to relate more to the second petition, and it's going to be covered in the filings on the 27th. But I think what they're referring to is, did it get filed, and was it filed in time? I think, and I'm guessing that they're talking about the two filings that you mentioned, October 25th and 26th, notice of continuing representation, and the was it the motion to disqualify?
Yeah, they're talking about Baldwin and Rosie about in the court transcripts yesterday about. So we know that Baldwin said that he was orally, giving his pardon.
Right, and Rosie said, "I'm going to file a written motion." But we're talking about documents, and so each side has argued, not fully by the respondent yet, but to some extent, the courts responded in language in the order. So, this is about the documents, this petition and filing and whatnot. So one side argued, well, they can't file those motions. They requested that they withdraw, and so they can't change their minds. Therefore, the court was correct to strike those two pleadings. And then what they pointed out in the petition for writ of prohibition was you can strike them and order that they not be considered, but you can't remove them.
Right.
And she acknowledged that. She said they're going to put them back. And so how to consider those based on what was said in the hearing. So Rosie, especially Rosie, so let's just stick with that. Rosie is saying, look, yeah, I did say, it's clear as day, I've never disputed this fact that I'm going to file a written motion in a couple of days. I'm not going to do it right here and now. I don't care what you say. And the judge was okay with that. But I'm going to file something in writing. And then what he filed said, I changed my mind. I'm not doing it. And here's what happened behind closed doors. And you take your best shot. And, I think I'm right on this. And, what have you. And so both sides have an argument on that. It's ultimately, if the Indiana Supreme Court feels it's appropriate to consider, I need to go run and get the power cord. You all read after where we left off, the next two paragraphs, and I'll be right back.
Okay. The trial court continues to misapply the ACR rules. On November 13, 2023, respondent entered an order purporting to correct the errors raised in the original action. Supplemental record of proceedings. Respondent then told this court that this order resolves most of the public access issues raised in the petition and moots the original action as set out below. That is not correct. And then it just says filings related to the June 28th order. In its June 28, 2023 order, the trial court noted that it was allowing counsel to agree to the probable cause affidavit and transport orders would remain sealed.
Okay. We get any more questions or comments? Did I answer Cherie's and the other person's question?
I mean, which Radar, she just said if you could summarize, but you pretty much did that, a couple minutes ago, eh? Do you consider that summarizing when you just talked a couple minutes ago, really?
Yep. So read what they want me to summarize, the whole thing.
Well, basically, just a summary of just what has been talked about so far, because there's 142 people in here, and if you 142 people could hit that like button, that would be amazing and awesome. Get us into that algorithm. Thank you guys for joining us.
How many likes are we at now?
You know what? Let me just check.
I think one thing that I think a lot of people get confused in, and it can be confusing, is I'm correct when I say the both of the writs are independent of each other, right? Correct?
Yes.
And so, like what we're talking about, like the documents that were filed for this writ, these were from the first writ that came out. These are not, this is not the writ that's asking for Gold to be removed, for the attorneys to be reinstated, and for the speedy trial, right?
Correct. And so people coming in late, we covered that at the top. So that's a good, but how many likes are we at now?
We're at 43. Let me see. Hold on. Let me refresh.
So when we get to 75 likes, let me know, and I'm going to summarize this whole thing in
we're at
in 5
49.
minutes.
Well, I figured there's 144 people watching. I think we could get to 75 and a donation.
Yeah, I think a 50% like ratio definitely deserves a quick summary. People may be on a 15-minute coffee break. So
you think that they're just sitting in chat and they're on a coffee break away from their computer, or you think that they're having a coffee at their computer and they're in chat? Because did you see that on my thumbnail, Travis? It said law and coffee time, time, or whatever it was. I put just like you put on the email.
Those are suggestions. They're gists. I would never use word for. We need a PR person. We need a designated tagline. I like some of the other ones I've seen you do in the past. So are we now? So they got a good dig in here, I heard.
Let's see here. Let's see if we could hit share 75, Travis.
Okay. All right. So let me know when we hit 75. We're at page. We're there?
No, we're at 58. Come on. Yeah. Do you know that probably 15 people just left, probably because they were asked to hit the like button? Let's see if they come back in.
Okay. So respondents then told this court this order resolves most of the public access issue raised in the petition and moots this original action as set out below. This is not correct. So they're going through in detail the chart. And I'm not okay. So let's get to Adam. Read or Sunny, page 11, first and second.
Go ahead, Adam.
First, even if these filings had a legitimate basis to be sealed, and they did not, every one of the court records must be accompanied by the ACR form, and there must be public access version and a non-public access version of these filings. None of these have been provided. Second, the agreement between the parties to keep these sealed was based on their assertion that the probable cause affidavit includes the names of juvenile witnesses, but nothing in ACR Rule 5B or any statute allows names of witnesses to be excluded from the public access just because there are child witnesses. Instead, the ACR rules provide that only the names of child witnesses in cases involving SO shall be excluded from public access. ACR Rule 5, C, 2.
And then go ahead and read that next paragraph.
Sure. This case does not involve child witnesses testifying in an SO case, and therefore this information cannot be excluded from public access on this ground. This understanding is confirmed by the fact that the names of these same child witnesses have been repeatedly made public in other filings, including the state's June 13th and September 25th filings, and attachments connected to the motion to suppress.
So there's the response on that. Couldn't have said it any better.
And there is a third. Do you want me to read the third?
Nah.
Okay.
Those are the two topics that come up the most: names of children, so on. Then let's go down on page 12, IC2, Roman numeral 1, C2. So this is first argument, sub-argument C, sub-argument 2, September 18th filing. I think this is going to have a lot of interest universally. So when do y'all read that?
This says on September 18th, 2023, Defendant Allen filed what is known as a Franks filing, wherein a defendant seeks to present evidence that the officer who prepared the probable cause affidavit misled the court to believe probable cause ever existed. He filed this as a public document. but the trial court thereafter, sua sponte, instructed her court staff that it be removed, excluded from public access. Specifically, in the transcript from the October 19th hearing, the trial court confirmed that it had changed the public access designation that counsel had used when filing, and instead made the Franks filing confidential.
And then read the quote, and this is page 5 of the transcript. This is the court, and read the quote.
It says, I had my staff mark the memorandum confidential after it had been filed and disseminated to the public because the actual warrant was in there, and that's covered under a miscellaneous cause number.
Okay, and now we're back to the argument. And, this is the thing. Last night I said we're probably going to see a reference to this. And then, so continuing back with her argument at the top of 13, read that next paragraph.
This is wrong. Miscellaneous cause numbers for warrants are only excluded from public access until the warrant is executed. After execution on the warrant happens, the warrant becomes publicly accessible, as demonstrated by the fact that the state itself has filed these same warrants as public documents in both the state's June 13th and September 25th filings.
So that's true everywhere. And you hear largely in federal court that things get unsealed. They'll seal them so that public doesn't have access to see that they're getting ready to serve a warrant on your friend or family member, and you call them up and warn them. It kind of defeats the purpose of a warrant, especially if there's evidence that's susceptible to easy destruction, like computer records or things that can be flushed down a toilet. And they're not unsealed until things have been accomplished. I don't know why I put duh. Even a blind pig like Travis can find an acorn every once in a while. I think that's for a different page. It wasn't this. So they're saying the rationale that the court had for marking the memorandum confidential doesn't exist under the rules. And then discusses next that even if the warrant could not have been excluded, could you read that, Adam? But even if the warrant
could not have been excluded, the ACR rules allow only the warrant itself to be excluded.
Even if the warrant could have been excluded.
Could have been excluded. The ACR rules allow only the warrant itself to be excluded, not the motion, memorandum, and all the other exhibits that were also filed on this date. A public and non-public access version of this filing were required, whereby only the warrant was excluded in the public version, and an ACR form was required. None of this happened, and all of these Franks documents were properly filed as public documents and should not have been changed by the trial court.
Then I put a note that yes, these rules apply to the judges. So right now, the latest order on this, one requested that new counsel determine whether they're going to proceed with the Franks motion and memorandum.
Amazon there now?
Hey. Sorry about that. Let me find this thing.
Duckin says her doggy says hello back.
Talk amongst yourselves for a moment.
Right.
Yeah, that's all good on there. All right.
Well, Judge Gull must feel like an Amazon driver the way everyone barks there all day.
Well, that's what I was like. He said UPS the first time, so I'm like, Amazon this time? I mean, it is like, I guess you guys got like that whole Amazon thing. What's that thing called again? Those what's Black Fridays or whatever they're called? Yeah, Black
Well,
Fridays.
Black Friday
Don't
is
you love
back
it?
at Friday, right?
Don't you love it how, I'm sorry, and I do appreciate that they do that, but they just got greedier and greedier with that whole Black Friday thing. It used to be like the week, you know what I mean? Now it's
Now it's
like
like
freaking
September.
spread it out. Yeah, right. You know, I got an air fryer yesterday. If anyone cares, my husband's
It
mother.
is.
Yeah, yeah. Who dis? But yeah, I gotta test out the air fryer today. That's my mission. Yeah, I was actually working on a video, and then the documents came in, and then it was like, Travis, you want to do a live? And I'm like, screw the video. Don't forget, we have a live tonight. That's on the Elvis Fields one.
See if
That
I
we
can.
missed yesterday because Travis was doing the document for the transcript last night on there. So let's see if 75 people hit the like button yet. Let's see. Dude, it's almost like nope, 71. We're getting there though. I'm sure 4 more people. Well, we'd like to hit 80 to be honest with you. We could just go for 1,000. That would be great. Can Rosie be sued for being illegally count? Well, at the end of the day, honestly, until the 27th comes along, really, that's when we'll see what exactly is going to happen here.
No,
You know
they're not getting reinstated.
what?
I mean, they're not
They're not what?
getting reinstated.
I don't think they will be, but you know what? I mean, you never say never, right? Like my gut could be wrong though. My gut feeling is like they won't be, but I mean, honestly, Kate. But Adam, don't you think though that everything that she was doing is basically she's having to backpedal and do it properly, like she's being told to do?
I
Doesn't
mean,
that
I think as far as like I've always said, that I think that this first writ I think holds a lot more weight than the second one does, and I think any action that we've seen her take has been directed towards the first writ, not the second one.
Mhm.
Yeah, I'm back.
Welcome back. Was it Amazon or UPS again?
No, a nice neighbor.
Brought you cookies?
My mom lives with us. She's in a scooter,
Oh,
and a nice lady across the street brought over a poinsettia,
oh, nice, nice, nice. Yeah,
which are grown in Hawaii, right? In the dark.
I have no idea. I just know that they're pretty at Christmas time. But so you
But
think?
they're a real nice lady and her husband, and my
Yeah.
mom.
You pulling my leg though on that? That they're grown in Hawaii in the dark, or is that like true? Or are you just pulling my chain?
I don't know. I think it is.
Pretty sure.
Like the lippins on her stallions are born black and turn white.
Alrighty. So, okay. So, I don't know what you want to do.
How
You
many
want to?
likes are we up to?
Well, you know what? Let me just hit refresh on that. I'm pretty sure it was 75. Let me see. I'm pretty sure it was 74. I'm pretty sure one more person can with their thumb. Yeah. Just touch
Let me
screen it.
pull this back up and
Travis, I bet you haven't even hit the like. Come on now. You probably didn't hit that like button, did you?
well,
Yep.
they say a healthy person
Hey, Sonny, I got it.
loves themselves, and you have to love yourself before you can find love, and a whole lot of cliches on that. But I just have an aversion to liking myself. Now I'll like you and Adam, but I'm not gonna.
Hit that like button. No, all good, all
Um,
good, all good.
I just hit the like button, so we should be at 75.
Isn't that nice of you, Adam, that you just finally hit the like button?
I forgot.
Okay, I've got 2 quick points, and then we're going to
Sure.
do a summary, and then we'll keep
Sure.
going on. So, a lot of stuff has come up about the children and so on and so forth. So, page 13, the bottom paragraph, she asserts there's nothing in the ACR rules, Indiana statutes, or under other Indiana court rule that allows the names of deceased children to be excluded from public access. Recognizing there's no basis in Indiana law to do so, respondent claims that exclusion, I couldn't believe this, mandated federal rules of civil procedure require it. Respondent is wrong. There was a lot of comment in different chats about, can the court cite to the federal rules of civil procedure as federal law? And pretty much the general consensus was no. I picked this out because Adam and others too frequently say, I'm not a lawyer. So I put here ACR Rule 5 makes it clear that the terms federal law and referring to federal statutes, not federal rules of civil procedure. And I put duh. That was picked up by the masses. And a reminder that law is mostly common sense. This is common sense. And thus the comments in the chat lined up. Now, not all law is common sense, and I apologize on behalf of my profession that that's the case. And a high percentage of legislators in state in the U.S. legislatures are attorneys, and that's why our tax code reads the way it does. A lot of statutes don't make a lot of sense, and I apologize on behalf of my colleagues for that. But this particular one, it's common sense. And so now this other thing at the bottom of page 14, I think PFD was an English major. I'll have to go back and look at that. But look at this, and you'll see this in statutory interpretation. You think you're back in middle school, junior high, whatever you call it, freshman year English in high school, where you diagram sentences. Do y'all remember that? Diagramming a sentence and thinking, what on earth could this possibly have any use for in my life? And this is what it has use for. Respondent implicitly acknowledges that the modifier Indiana at the beginning, this is Indiana court rule, and that it talks about speaks to minors in the present tense, leading to the conclusion that only applies to living minors, not deceased minors. Well, many people, including myself, attempted to say that it doesn't apply to this or that, only applies to deceased, not living. Well, PFD and her colleagues put this in very clear language and referring to the way terms are used in the English technical sense. And I was really impressed by that modifier. And I know present tense, but then the next page, and then we're going to go to a summary. Next page, the understanding that federal rule 5.25 does not operate as federal law, maintaining exclusion under the ACR rules is confirmed by the fact that the state has repeatedly made public the names of the two deceased girls in court filings. yet the trial court never ordered the clerk to exclude the state's filings. And I put a note here, bias. That is an example, if it's true. I can't imagine that PFD would put that in there if it wasn't true. But if that is true, that is clear bias. Bias, actually, if you look it up, is a propensity to favor one side over the other. So it'd be bias in favor of the state, and prejudice is a tendency to disfavor someone over someone else. But prejudice has taken on, a lot of baggage in terms of disfavoring someone because of their race, nationality, sexual orientation, gender. And so prejudice keeps being used less and less, but I think we all know she's trying to say, I'm trying to say, this to me is clearly showing bias and or prejudice either towards the state or against Mr. Allen and his counsel, that complaining about things the state has done. So we're going to go up to the very, very, very top.
Travis, can I ask you a question real quick?
Sure.
So when I was reading this, like you said, it says, yet the trial court has never ordered the clerk to exclude the state's filings. I was a little confused because in that chart that was back on like page 5, I think it was, or something, I thought a couple of the filings that they're claiming were withheld from public were state motions.
That they were what? What was that last part? A couple of the filings were what?
That they were state motions or state filings. Because if you read that chart, I think one or two of them, I think at least was ones that were filed by the state that they're claiming are being withheld from public view.
And did I misspeak about that, or
well, no. I mean, it says yet the trial court has never ordered the clerk to exclude the state's filings, but in their own writing earlier in the document, they list a couple of the state documents as being excluded.
No, what I'm pointing out is that she very specific context that they were trying to argue on the court's behalf that and we'd have to go look at that filing, which we won't do right now. We'll save for another time, but that the court in some manner said that, this is improper or shouldn't be made public because it includes the names of minors. And this is the part of their response, the court's response, where they argued that federal law precludes it. They've explained, one, that's not what the ACR refers to when it says federal law. Number two, this. And then they say, number three, we know it's not federal law under the ACR is confirmed by the fact the state has repeatedly made public the names of the two deceased girls in court filings. They don't refer to when or what. Yet the trial court has never ordered the clerk to exclude the state filings that mention the names of two deceased girls. That's what they're referring to. And I don't know if that's the case or not. I would assume that her representation is accurate in that regard. So top of page 4,
Top of page what? 4?
4. So whoever asked for the summary, bless you. Ms. Smith, PFD, knowing that the state would appreciate a summary, that you all would appreciate a summary. She summarized it best anybody can do. And here's the summary. Yeah, the court corrected a few errors in its order that were recently filed, and we went over that, ordering the clerk to do different things, but the tone and the approach set forth in the brief causes concern of continued misunderstanding and misapplication of the mandates found in access to court records rules. And, in summary, these are mandates. They're not, meaning they are not discretionary. There's no room to wiggle around what to do. And then also in summary, trial court has no discretion to ignore absolute duties in the ACR rules. And that you can't shove this off on somebody else like the clerk. The rules make the trial court directly responsible for compliance, especially when it becomes aware that the mandates are not being followed. May not abdicate those duties. You can't order the trial clerk to violate those rules, and it does. So you can't get around the rules by ordering the clerk, for example, to do something, and then the clerk complies. That's not enough. In summary, continued, the relator and his counsel have recently learned that respondent is the someone who ordered documents to be pulled, designated as confidential, et cetera, and that, yes, in summary, the court did issue an order that they claim, the court claim, corrects all of the errors identified. However, the petitioner begs to differ and has outlined 8 specific continuing violations of the ACR, and acknowledging 2 of the violations have been corrected, that the contention that the response filed by the respondent, the court, has mooted the motion, and it's mooted, not muted, is not accurate, and that this petition is important because it looks as though there's going to be continuing errors if the court doesn't come in and rectify this. In addition, it reaches has broader implications that are important. And so the court should also rule, because it's a unique opportunity to, quote, educate the bench, which are the judges of the state of Indiana, the bar, that's the attorneys of the state of Indiana, the media, and the public, which I presume is between media and public, is including YouTube and other content creators, as to the mandates of the ACR rules. And that's the sum and substance. And, it's referring a lot to their original petition. It's referring to the response, and there's 3 citations to the transcript. I think they've showing why they needed that transcript. They were in the dark on why certain documents were being withheld or not being filed, not in the CSS system. And I think we can go down to page 21 and someone can read the conclusion, and that will sum things up for us nicely.
Let's see here. 20. Sorry, what page am I on? The conclusion there.
Yep.
Okay. Okay, let's see. Respondents claim that their original action has been mooted as a result of its November 13th order is incorrect. Instead, respondents' response demonstrates a continued misunderstanding and misapplication of the responsibilities and requirements of the ACR rules. This court should issue a writ mandating that 1, all of the documents in this case are immediately made publicly accessible, and 2, no document may be excluded from public access without full compliance with the ACR rules, including the ACR form and the submission of public access and non-public access version. Respectfully submitted, Maggie.
So let's go back to a comment that Adam made and other. So yes, these writs are separate, completely separate. Got a petition for a writ of mandamus regarding the filings, and you can see what they're asking for. All of them publicly accessible, and that no document excluded from public access without full compliance of the rule. And that's you designate a public and a non-public version of the pleading, and that you file an ACR form with the exemption, the rule that you're claiming it's exempt from total public access. And so, yeah, that's completely separate than the petition for writ of prohibition regarding what happened in removing counsel and not allowing them to come back as pro bono counsel, completely separate. However, and they're separate probably by design. Do I know that? No, this is speculation, this part. Think there was a plan and discussions that, what are the issues here? And they said, well, we got the court filing issues, and then we've got the Sixth Amendment issues. And somebody said, well, let's separate them because while they may have some overlap, the documents and the stuff with the clerk appear real clear. And so let's go with that. And then that may make things a little bit easier. So for example, if the Indiana Supreme Court rules that the Frank's motion should never have been sealed, made confidential, pulled, whatever was done, or that if it was proper to pull certain aspects of it, they didn't comply with what you need to do if you want to do that, that's going to help on the other petition, because that was one of the claims of gross negligence and or incompetence. But outside of that, they're separate. So, if they get that kind of a ruling, then they would say that would be one of the arguments that, or they may say that issue's pending, but you can't argue that that's you can't argue that that's gross negligence. And it's an example of the court prejudging something based on not having a clear understanding of the law.
How could I not be awake, Mustang?
Question.
The dogs are barking. How could I not? Is it because I'm looking down because I'm going to the different tabs and looking down at the chat or the comments? You are the best. You hear that, Adam?
Oh, yeah. Thank you. Cheers.
You guys, or did you have a typo and you just meant sunny?
No.
Sounded like it. Hey, did you get a new drink? Did I just stutter?
Yeah.
Did you?
Yeah, I just made myself a whipped chai.
I hate being diabetic, eh? I pretend I didn't have a hot chocolate this morning either, with marshmallows in it. My doctor told me it was okay.
Well, good.
My doctor is Google.
Probably not the smartest thing to drink on a live because I'll probably get whipped cream on my nose or something.
Well, no, but I remember when you first drank it, you had a mustache going on there, and I was like, I could look that through the screen right now. Anyways, so is there anything important that you want to say, Adam?
No, I mean, I thought this was a well-written document today. And like I said, I think that, between the two writs, I think the first one, I think that she did take care. I think she did clear up a lot with her order on the 14th or 13th. But the outstanding things, I think this is, addresses them in a respectful manner. And I think the first writ has more grounds than the second one.
I think you should go sit in the naughty corner and rethink about what she's done.
But I think the first writ's really just to correct these things. It's not to have her removed. I don't think anyone's alleged.
Right. It's just to correct. It's just basically really just saying, like, look, follow the rules. Like, it should be done.
And that's good. Everyone should, there should be accountability for everything.
But what's getting me, it's kind of like Sheriff Lesenby calling off the dogs. Shouldn't she know this shit already? Like, why does she have to be told to do what the rules say anyway? So that's my only thing.
Well, everyone should know how to do their jobs, but I think we've seen some instances in this where people
and
abused that.
YouTube, quit freaking giving me yellow on freaking an 18 stuff on stuff that's not even exploitive and stuff like that. So they're in the wrong too. Do you know that in 2024 there's going to come out rules for about using AI because people are like, you're going to have to basically claim your content has AI in it and different things in 2024, because pretty much, by year 2025 you can just lay in bed and hey AI, make me a video. Well, you can kind of do that now almost, and stuff like that. But anyways, YouTube has been doing a lot of rollouts with changes, by the way. So if you guys happen to see more ads, sucks to be you. It's one of two things is going to happen. Either you get which they want you to do, which is pay for the ad free, like I have, and then they'll probably increase it again next year, or you just put up.
Can I comment on Charmaine's comment to AJ?
To AJ?
It was before that. You just took it down.
Let me find it. AJ right here. I see it.
So my feelings on that, it's this is just me personally. I don't so mainstream news, I get 4 or 5 different sources that cover a broad political spectrum. It's the only way I can get the most accurate pulse on something. So it'll be moderately left to moderately right. And that stuff's tracked very scientifically, if you want to know where things are on the political spectrum, just go to Pew Research, PEW, like as in Pepe Le Pew. You can find that. And then on YouTube, like anything else, you're just going to want to check out the source. And so you look for, and it's true crime. Is it, you don't need to be an attorney to be a true crime aficionado, and especially people who are armchair detectives, and that's part of the intrigue of it. And then you just kind of look on the legal aspect of it. Are they a lawyer? Are they seeking out guidance from people in law? And then, you want a couple, 3 perspectives. However, and I hope I'm one of those perspectives, and I hope people get some sort of value from it. But there are some things on YouTube. I wouldn't get on YouTube to figure out how to tattoo myself. I wouldn't get on YouTube to figure out how to pierce a sensitive area of myself. I would not get on YouTube to determine, I don't want to get too controversial, anything medical, probably not a good idea to get on YouTube for. In this day and age, it's not like in times past. You have to check out a little bit who you're getting your information from. And, that's all I'll say on that. I will
Travis,
say
you should check out
be associated with any channel that was fringe or crazy.
Well, Adam was going to say something to you, Travis.
Travis, you should check out my self-piercing and self-tattooing channel.
Right.
Hey, I took a flight on your guys' airline.
Did you go on it?
Almost as good as Virgin, when Virgin first came out. I mean, it looks like it was a lot of fun. I'm still a little miffed I didn't get an invite to the
you talking about the Alcatraz? Did you watch that one a little bit?
Yeah.
The Alcatraz. That's Sun and Sunny Airlines. That's a members only thing, though.
Yeah.
Take you on a ride around the world.
We haven't done one in a while.
But yeah, no, Alcatraz was really cool. Taking a tour over there with Google Earth and being able to walk through it. I love stuff like that. That's cool. Like, when am I ever going to go to Alcatraz? Probably never in my lifetime. But
so cool. When I was growing up there, it was inhabited by American Indians, and they had taken it over, and in a sign of protest, and they were citing a treaty that abandoned federal lands, revert to who owned it originally, which would be the American Indians, the indigenous population. But I remember in support of that, my parents, we went and brought a huge boatload of food over there. And that was going on. And the tourists in San Francisco, you could, all these telescopes that you put a quarter in, and they had signs up. And but yeah, my parents felt there's some American Indian in my family on my mom's side felt that there were a number of incidents, wounded knee and other things that had been happening. They didn't feel the American Indians were being treated fairly, and so they supported their cause. But yeah, I go back to Alcatraz for a long time. Then it got converted, and they restored it. And
we came back around, Travis. Charmaine was like, I thought Alcatraz, but and then all of a sudden you went for a ride, and then all of a sudden came back to Alcatraz, and I was like, Charmaine, come on now, we're still on Alcatraz. Come back to it. Go ahead.
Alcatraz is a really cool place to visit if anyone ever gets the chance.
For sure. You should not miss the chance. And you need to plan ahead. It's not a last minute thing, especially in the summer. The boats sell out very, very quickly.
Yeah.
And so if you're going to do it, it's one of those things that you should reserve your spots for you and your family a few days ahead and work around it. It's not the type of thing, sometimes when I travel, I like to play it by ear and, we'll just see how we feel. Alcatraz in high season, it's pretty difficult to get on.
Right.
Ivy says, what tribe are you?
We are one of the civilized tribes. Cherokee.
There you go. On there.
That's not my term. The Indians, the American Indian, indigenous peoples identified to set themselves apart from other tribes, which were warring tribes. They said, we're part of the civilized tribes, and they're the ones that met with the people in Washington and got snookered.
I'm part of the Track Tribe. That's the song that you hear when you watch the intro. Does that count?
Oh, yeah.
That's what I thought you said.
Yeah.
That's what I thought you said.
I'm Delaware Indian. What's true?
Do you know how many people though think I'm Native?
Yeah. So you guys got screwed over real early in the country's history.
Look at Raider. She's like snapping her fingers at you, Travis.
Hey,
She's
there's
like,
plenty of room over there. Plenty of room over there. The art that I collect is Northwest Indian art. The tribes that do the totem poles, but they do a lot of different art besides totem poles. But you see that the Seattle Seahawks have adopted that art form on their logo. But, there's a museum in Vancouver, the Northwest Indian Art Museum. I mean, I could spend a week in there.
I'm still trying to figure out what Radar's question was. Was it the Shawshank thing? Because
Sure.
I got she says, Travis, can Travis answer my question, Sonny? I'm like, what question? What was the question? India. Oh, I think I don't. What's the question? Put the question there again there, Radar, and I'm sure Travis can answer it for you. Boom, boom. Sonny. Why is that coming to my head again?
You're going to get a copyright strike.
No, I can't get it for singing it ourselves. Freaking if anything, they'll block the channel if I sing, probably. I really do need your help with that. Okay, Radar must be drinking early this morning or something. I don't know what she's going on about. I really do need your help with that. I tried, but so overwhelmed, I gave up. Radar, what are you talking about? What are you talking about? Do you have any idea what she's talking about, Adam?
No idea.
Radar.
I didn't see.
Yeah. Drinky drink.
Oh, okay. She's talking about and I and Travis isn't a law enforcement, so but Radar asked about, is it typical that LE would arrest someone and yet not clear anyone officially and keep the tip line open? And I can answer that. It's not unusual at all. There's countless. I've seen countless cases where the exact same thing happens.
Yeah. So clearing rarely happens unless the police or law enforcement, and I do know a lot about law enforcement and policies and things because of the type of law I practice. But so there's a couple of things there. One, a lot of that is determined by the prosecutor, who's going to be officially cleared, if anybody, but it does happen at the LE level. And one of the most famous cases is somebody being officially cleared is Jewel, the security guard at the Atlanta Olympics with the bombing. There's a really good, not documentary, but a really good docudrama. I can't remember. I think it's on Netflix. I think it was multi-part, excellent, about that. They officially cleared him in that case because, they completely messed up. It's very rare and considered now, if you make an arrest and there you had they'll say, well, so-and-so is a person of interest. Generally now it's, you don't want to say no, they're no longer a person of interest, or you don't really see that. But it doesn't really matter anyway for purposes of true crime fans who I know like to discuss, especially when it's, quote, unsolved, unquote. And this still isn't solved either in the legal system or the sleuther system. But, that's part of I think, a large segment of the fans of true crime. That's part of the fascination and trying to solve it and taking a limited set of facts. That's why you and I like connection so much, Adam. Law is trying to analogize to other cases, make a connection. So, in general, you try not to, either as a police chief or a county sheriff, you try not to clear people. You make general statements. Well, are they a suspect? And you'll see top-notch detectives say, right now, everybody on the planet is a suspect. That means they're keeping an open mind and they're
smart.
Following most detective schools, when you go to class to be a detective, the first thing they teach you is that the primary objective of an investigator or detective is to seek the truth. And I think there's part of human nature is to solve things. That's why true crime has this huge following, that, there's something innate in us that tries to fix the problem or solve the problem. And we ask a great deal from investigators, detectives. You have to put that aside. You have to ignore that instinct. If it is an instinct, that's an assumption of mine. but it's clearly harder for some detectives as others. And we've seen that. It manifests itself in cognitive bias, confirmatory bias, and, that DNA completely shows that they got the wrong person. And prosecutors and detectives, even with no ill motive, no spite, nothing, they later on admitted, not always, unfortunately, admitted that they developed tunnel vision, got blinded, things started appearing, and instead of, an objective person saying, well, this points in two directions. This could point to A or B. They just saw it as this points to our guy. They don't see it pointing to anybody else. So you generally try not to put in the media, other suspects that you as a community may have discussed as who you think's number one or number two. It should not translate over. You're not going to get help for your person that you think's the most likely suspect. And again, I don't know the case. I know from being on with Sunny and Aspen that there's been other people. Like last night, supposed to be something about Elvis, and
Oh, yeah.
I preempted the show. Don't want to know what it is about Elvis. I saw the poll that said it needs being looked into further. But a good detective or a good team of detectives, just because an arrest is made, they don't stop looking typically. Now, sometimes they do because the evidence, it's just a waste of time and resources. I mean, so if you've got a ton of DNA and it's DNA that's not been corrupted, DNA that hasn't been transferred from an evidence tech to something else. I mean, you have good solid DNA. You have, for example, video evidence. You have video of suspect coming into a building. There's a gunshot with 30 seconds later, suspect leaving. Right. There's a body in the apartment, deceased, gunshot wound.
Like the Boston Marathon bombers. I mean, they have video evidence of them placing the devices. They have video evidence of them leaving with.
Okay. Was there anything else on that, Adam, or can we answer Charmaine's question?
Yeah, let's answer Charmaine's question.
Yeah, because this is the one from yesterday we talked about. Yeah, Charmaine, about RA going into the chamber.
Charmaine asks rhetorical questions because she's smart enough to do it. She's trying to educate other people here. She knows the answer. And yeah, I'd be happy to talk about that. So in the transcript, there was a request by Mr. Rozzi, one of the two attorneys that got removed, saying, well, the way I've seen, and I'm paraphrasing, the way have seen disqualification motions in the past is that the defendant is given an opportunity to state what their position is about the removal. Do they object? Are they in support? Have no position? So, Judge, I appreciate you don't want all of this going out in public. What do we do? Do we bring him back here? And the judge said, well, I don't know if the DOC, the people responsible for keeping him safe and moving him around from place to place. I don't know if the DOC would be willing to do that. And she goes, I don't know if I would be comfortable having Mr. Allen in here. And I think that's what she's referring to. How much can be taken from that as to bias, let's say. And what I said yesterday, my personal view on that is that, one, as Adam pointed out, it's difficult from a transcript, reading bare words on a page, to get, you clearly can't get, if someone's being facetious or snarky, or, that just doesn't come out. You have to look at the context. So number one, at my first reading of it, I'm kind of like, well, God, that's shitty. You're too good to have a defendant in your office. But having time for reflection, part of that reason may have been that would have been unfair to Mr. Allen, to put him right in front of the court, to where the court might develop a subconscious bias or prejudice, because when you're that close to a person, you're just able to judge more body language, the slightest facial expression. And so she may have just said, not sure I'm comfortable with having him in here. Most judges' chambers are, 10 by 12, 12 by 14, unless you're a federal judge, and then it's, they have like 3 rooms and they're, 40 by 30. But anyway, it's room for a desk and 2 chairs, typically, maybe 3. Not those fancy courtrooms they show back in chambers in Boston where, they're big. They're just not. And so, I don't think it was anything personally, is where I'm at right now, against Mr. Allen, that she didn't want him brought into her office or chambers. But it was effectively rendered moot, not mute, moot, when she said, you've represented to me, the court, that you spoke to Mr. Allen, that he doesn't want you removed. I take you at your word. You wouldn't lie to me about that. I wouldn't lie to you about anything, responds Mr. Rosie. And she says, that's good enough for me. And so, I don't know if there's anything else, Charmaine, that you wanted to talk about with regard to that, or if you wanted me to express, because I know it's a rhetorical question, but I hope I captured that. And then, Sunny and Aspen may have thoughts about that.
Oh, sure, if I was listening, but I wasn't. I was on a different little page.
I agree. I agree with you, Travis.
I agree.
That was my take as well.
Yep. Sorry, I was doing something else behind the scenes on there. As you were on,
honestly, at first blush, when my reaction was kind of, whoa. And I said, well, my job is to be, as neutral as possible, and to give reasonable, within reason, both sides of it. And I could easily see why people would look at that as a negative thing, preconceived by it. Now, there's other things she did that tell me that she was biased at times and that preconceived, but we don't know whether it was okay for her to do that or not. The deciding based on the 5 or 6 things she listed. We don't know if under Indiana law it's okay for her to make a judgment without providing notice and hearing. And we're going to see what the court says about that on the 27th. And
Do you see there
probably
was
a response. And then, the court will have to decide if they think it's appropriate to decide.
okay? See the rest of Charmaine's question there. It says, but Travis, is it allowable generally or typically for defendants to be in those meetings?
It's not. I've never seen it except, like I said last night, where co-counsel is typically in a civil case. Co-counsel is a licensed practicing attorney and a party. That's not all that unusual, but when they say counsel in my chambers, there's never anything about that. I've seen waivers of it's just one attorney, but he has a paralegal. I've seen them ask for permission, Your Honor, or a law clerk, a law student I'd like if we have anything in chambers, my law clerk to be there, and judges are happy to do that. But a defendant in a criminal case, that's not the standard to bring them back into chambers.
Yeah, because I was going to say, I remember you saying that yesterday when we were talking about that
Yeah,
it wasn't a normal.
not in Texas, Oklahoma, California, Nevada, Idaho. Well, I haven't done criminal and all those. So most of my criminal experience is in Texas, a little bit in Nevada, and a little bit in Oklahoma, and never seen that. Did anyone follow OJ real close? I don't think there were many in-chamber meetings. I don't think OJ was ever invited into in-chambers meeting.
Not that I recall from it.
I think Rosie followed it. I think he mentioned it in the chambers.
Yeah, he did follow it.
But the state would have been objecting because OJ, doesn't matter whether you agree or disagree, is a very likable person. People said that uniformly. He's one of those people walks into a room.
Yeah, and he's just a presence. Yeah.
Bigger than life, big presence. And, I'm sure they felt Ito was starstruck enough. They didn't need any, one-on-one exchanges. And so I don't know. And Charmaine, is that something that's common in Canada that you know of?
I wouldn't know because I don't really pay attention to true. That's not something I would know. Yeah. Charmaine, curious if you would know that. I don't think so. We're pretty strict over here. Okay. Yeah. We're pretty uptight over here.
So on that show y'all did on Canadian crime, or maybe it was Canadian murders, did you all go over that couple, husband and wife, and the wife and her husband killed her sister?
Oh, the billionaire? Wait. In Toronto?
Yes.
I can't think of their names right now.
No, we've only covered.
Great documentary on that one and how
Sherman?
Bernardo. Oh, Bernardo. Yeah.
Oh,
The
Bernardo.
one that they got a plea deal for the wife,
Yeah.
even though she may have been more culpable, got a much, much better deal than the husband. And it was clear she got the deal that she did because of her lawyer being very, very skilled. And number two, very, very quick on the draw, seizing the opportunity. And so it was an unfair, unjust, what each of them got relative to their responsibility, culpability for the crime. But I thought it was fascinating.
Yeah, so yeah, we did that on the first live. So our second live was last week, and next week we're going to be doing the Robert Williams one. That's for that Air Force guy, whatever his name is, Robert Williams. I just said it. I remember that one because I actually watched the documentary of that one not too long ago because somebody had brought it up, and I was like, oh, I haven't heard of that. And then as soon as I watched it, I was like, yeah, actually, I did see that one. That's a pretty big one out there as well. For that. So anyone that's watching now on Saturdays, and just a new thing, Charmaine and I, we're both Canadians. I live in BC, Vancouver. She lives up there in Alberta. So basically it's, the intention was never to have a true crime channel for myself here. And so here I sit 3 years later. And so I figured, Charmaine, we were talking about it because I'd been thinking about it and to do True Crime Canada. So we've done it on Saturdays. So if anyone's interested in anything about Canada, of course, in true crime and stuff like that, then Saturdays is when we do, or at least at this moment, is Saturdays for True Crime Canada. And next week, like I said,
Ken and Barbie, I don't know if
Russell.
that's their real names or the name of the documentary, but it was fascinating. And then, do we know where Barbie is now? She got to be out by now.
She's married with kids.
Yeah. Two, Charmaine said her lawyer's brother.
Yeah.
Crazy, right? And it was, so it was Doug.
That guy was older. That guy her attorney was older that negotiated that deal, wasn't he?
It's been a while since I watched that documentary.
Well, I'm going to start tuning in on Saturdays, and then I will know.
Right.
It's true enough.
I know. I'm going to crash one time and just sit there.
You know what? No, let's talk about Saturday, Adam. You were too busy. Instead of joining us on the live, you were too busy watching Art of Deduction. I know you were because you'd messaged me, and I was like, oh, I said to Charmaine, yeah, Adam said he was coming on, but I think
it was a dumpster fire over there. I couldn't stop watching.
Right?
And I don't mean that. I don't mean that. Right?
I know he's over there. We waited.
Do they televise a lot of the trials in Canada?
No.
Do they televise any?
Well, oh shoot, no, that's I was just about to name one, and then that was the United States one. Charmaine, that's a question for you again because I haven't seen one.
She said never.
Yeah, see, that's why we suck.
But it's more like the UK where they don't,
They're like, seriously. I mean,
so it's like federal court in the UK, and it's not.
No.
Yeah,
this is why US makes it so much better with all your guys' amendments and all this stuff.
Right.
Now, to counteract that, I will say
we have sketch artists.
Canada, UK, the Commonwealth countries, Australia, the media access. So in every courtroom, there's a designated area for media. And, that's the fourth estate. And so, the media is in there, and you have to rely on the media to get the account. It went away. Cameras in the courtroom, and then it went away.
Charmaine said cameras in the courtroom is not here.
It's not a thing here in Canada. Cameras in courtroom.
Now, what's the murder rate in Canada?
Jeez.
So in the U.S. in 1990, it was pretty close to 10. So that's 10 murders per 100,000. Then it started a decline, and it got down to about half that until right before COVID. And then 2020, it started to trend up again to about 6.
Because everyone had to be home with their families.
Yeah, you know, you can't get away. And
Well, it says here Canada's murder homicide but this is showing for 2021 was 2.07.
yeah. The
Oh,
only places above the U.S. are
Like world.
Caribbean islands, Trinidad and Tobago,
Congo.
You know, so you know.
Now, what's the USA population? About 340 million, 50 million? About 350 million, somewhere around there, isn't it?
Yeah, so there's about 2,200 murders a year in California. They're number one. We have about 2,000 murders every year in Texas. We're number 2, and you know, it goes up and down. It's been trending down, and then you know, people argue over whether you know different rates or because of Texas has death penalty, and you know, that debate's never going to be won. But you know, clearly why we are so high compared to EU countries and Canada and others is guns. I mean, there's just.
Thank you for saying that. In my head is before you said that's exact word that was in my head, and all of a sudden you said it, and I'm like, thank you, because that's the truth of it.
Yeah. So you know so they said, well, there's this balance. The founders, you know, created Second Amendment. It's not just for protection, but that if the government, you know, it's to safeguard against tyranny. And we do have, you know, more murders, you know, more shootings, more killings. They don't say this in print, but in essence, that's the trade-off, and it's acceptable. I'm not advocating one way or the other. You know,
you want to start a war?
Many of people to advocate for their 2A or you know, whichever way they want to argue it. A lot of very, very capable people, but that's essentially the trade-off. That if you don't have the Second Amendment and the protections and the ability to carry it
you popped out
open and stand your ground, that you know that you risk having a government that becomes tyranny, and this is the check and balance to prevent that. So yeah, but it's clear. I mean, there's no other. And then we're essentially a two-party system in the States, and each party has stuff to say about the other party when it comes to that and every other issue.
Yeah. Usually in lives, you don't talk about politics or guns.
I apologize.
Oh, no. Those just are topics that usually will start a, third world, or they're in the chat.
Kind of that, are off limits at Thanksgiving, right? No
What?
religion, no politics, no guns.
You can talk water guns. I don't care. Talk water guns all you want on there, but that's about it.
I like to bring it up. I like to bring it up right when I'm ready to leave.
Yeah, piss people off and on there.
Yeah.
I think that I don't know, like between Canada and US, each of them we have our pros and cons, right? Like I love the fact that you guys have the accessible. What, Adam? What?
I mean, Canada's maple syrup death rate is much higher than the.
It is absolutely. Pretty sure if I died for saying sorry, probably be dead about 10 times over, apparently. But that was funny actually. Maybe we'll play one of those clips next week. There, Charmaine. There was top 10 things only kind of like only Canadians do. And the first one, you might not understand this one, but it made me laugh so hard because not the first one, but the 10th one was ketchup chips. And it's such a Canadian thing, but that was the 10th one. And I had to send it to Adam because it was like, it's such a Canadian thing. Like you don't even think about it. When I first learned that the States really didn't have ketchup chips, they do, but it's rare. Here, it's like in every store, right?
I found them in Washington, D.C. and like that was about it.
Yeah. Someone remind me who the Princess of fucking Darkness is. Go ahead, Travis. You can take that one.
The Princess of fucking Darkness is
Maggie
the Honorable Maggie Smith, Esquire, the principal author of the petition and the response that we were going over today. And
I still remember the first time you said that. When somebody's just talking along, a lawyer's talking along, and all of a sudden out of his mouth comes, and there's the Prince of fucking Darkness right there.
It's a term of respect, clearly.
Absolutely. Yeah.
Maggie, if you're watching, I love your work. Don't know if she watches here, but if you're watching, term of respect, and just love the way you phrase things in your legal writing. Awesome.
Oprah, if you're watching, I really want to one day meet you and be on a show. So that's just a shout out to Oprah because I know she's watching probably, and we've tried to have her on the live a few times, but she's kind of playing a little hard to get at the moment. Maybe
we have to keep bumping her as these documents come out.
Yeah, maybe we'll get Tommy on our show. So don't forget that anyone that is watching, whenever you guys do a donation, we're on that. Get Tom Webster to do a live with us. So that Tommy song, if you hear Tommy go off during a super chat, that's the whole purpose. Tom's losing his job December 1st, so he's going to have to build up his. I think he's going to have to be just a little nicer to me. I think. Right? Not that he's not super nice already, but yeah. So Tom,
not the way to make him nicer.
I gotta run in 5 minutes.
No, you
I actually have to go in a minute too.
Yeah. We're all good here. But anyways, so thank you, Charmaine, for that earlier super chat. Thank you guys for joining the live today. Thank you, Travis, so much for answering me back right away there because he was like 2 hours, and I'm like, can we do it sooner than later? Only because you know what was going to happen? I have been up all night, So I was like, oh, if it gives me 2 hours, I'm going to be falling asleep by that point.
You up all night, cooking stuff in your new air fryer or what?
No, I was watching different things on YouTube throughout the night. And the next thing I know, my husband gets up at 4, his alarm goes off at 4:10 in the morning. And I'm like, well, since I'm awake. And then I was starting to make a video, and it's Brian Koberger's birthday today. So of course I had to take a little poof on him a little bit. Happy birthday, Brian Koberger. You're exactly where you need to be. I'm sorry, guilty. That's public opinion guilt right there.
But anyway, maybe they'll give him some vegan birthday cake.
But tonight, you guys, don't forget at 7 o'clock PST, 10 p.m. is the Elvis Fields live that we were going to do yesterday, but we'll do that tonight instead. So we'll see you then. But Travis, thank you again so much for your time. Just a pleasure to have you on to explain this. And again, we love the way that you're just like, you're not pro prosecutor or defense. You're just, like straight up the middle, about your voice. Do you know what I mean? It is really nice because you're not coming in biased, just kind of letting people know what's going on and what kind of, the typical way things are. So we'll see on the 27th. Oh, shoot, I just missed 11/11. It's 11/12. But anyways, so thank you so much for that. And yeah, so 10 o'clock EST tonight, you guys, for the next live, okay? And
Right.
Travis, did you have anything else to say before we get going?
Thank you. Thank you for having me on. And we don't see you before. I hope everybody has a wonderful Thanksgiving. For those of you in Canada, whatever you do.
We already had ours.
For those of you in the UK that got nothing.
Right. Husband.
Hello. And we'll talk more probably Monday.
Or tomorrow when more documents come out.
Yeah. I feel like
or later this afternoon.
I was gonna say I feel like I'm booked all week here because I feel like I think Alexa's coming on tomorrow, and then she was asking if I was doing Thanksgiving. Well, I have to. For all you lonely people in the world that don't have anybody, you can just come here, come join the family. Even though we celebrated ours, but still Adam's Thanksgiving too.
5 minutes. 5 minutes after we end the stream, new documents.
Documents. Oh, let me just check that, Travis.
I just did. I checked my email.
We're good? Okay, perfect. Okay, guys. Well, you guys take care. What time? Oh, Tom's on at 8 Eastern.
Yes, so we're on at 10.
Yeah. So Tom, just keep it short, keep it quick. All right, buddy. Anyways, you guys take care. We're out of here. Thank you guys so much again. And please hit that like button and subscribe if you have not.
Thank you guys
so much. This is Sunny Justice and Aspen Connor from It's a Crime and Shame, wishing you all a good night.